Well, more than 100 First Nations are urging Premier David Eby to uphold Dripa. Now, in a joint statement from February 9th, nations including the Lilwat, Squamish, and the Cowichan tribes say that amendments to the Declaration on the Rights of Indigenous Peoples Act would undermine certainty, reconciliation, and the shared prosperity of British Columbia. All of this comes as Premier Eby has announced his plans to make changes to the act. He says his government will be amending it in order to scale back the power that courts have in shaping reconciliation efforts in this province. The matter has been dividing not just BC politicians, but residents as well, and some Indigenous groups. We're joined now by two people who see the issue differently. Aliia Warbus is the Conservative MLA for Chilliwack-Cultus Lake and a member of the Stolo Nation. She is in favour of making amendments to the Act. Aliia, good morning to you.
Good morning, Stephen.
Thank you for being with us. And Robert Phillips is the First Nations Summit political executive. He's a member of the Canim Lake Band. He opposes amending Dripa. Good morning to you, Robert.
Good morning.
Thank you both for being with us. We appreciate it. Robert, to you first. Premier David Eby ramped up talk about amending Dripa after the BC Court of Appeal ruling over the Mineral Tenure Act in December. The court declared that BC's mineral tenure system is inconsistent with UNDRIP, and Premier Eby thinks that the court was overstepping in that decision. What do you think, Robert?
Well, to be very clear, we're in disagreement with any alignments to Dripa. As you know, the United Nations Declaration on the Rights of Indigenous Peoples are basic human rights. And for the last 5 or 6 years, we've been working with the provincial government. We commend BC NDP government as well, all parties who came together in aligning this, historical piece of legislation. And we're looking at aligning all laws, and I do believe it will expedite this mad dash for, cash almost in regards to these major projects. And what I mean by expediting is it will align the laws. It will ingrain in laws and legislation, policies, procedures, enforcement, regulation, all of those things that are necessary so that we protect the lands, resources. All of these projects can't be done at all costs. And UNDRIP, is one of those things where Dripa is, and we have federally UNDA, the United Nations Declaration Act as well. And this will ensure meaningful consultation and the free, prior, and informed consent.
And so in your view, then, what have some of the impacts been of Premier Eby signaling that he wants those changes to Dripa?
Well, I think if this happens, then it will just delay. In the last 5 or 6 years, we've been working very hard with the provincial government, working with senior officials, and we continue to do so. But if we see delays, then that's going to affect not only things like the Mineral Tenure Act itself and the reform, but also the critical minerals strategy that they're talking about federally, provincially, where $1 trillion will come into Canada, as well as major projects in British Columbia especially. So here we are trying to work on a process where we're setting up a framework around Dripa itself for all British Columbians, not only First Nations. And then if this happens, then that will, I do believe, expedite the process. And so we're very concerned when someone says they want to tinker with it, if they want to amend it, and especially if they want to abolish it.
Now, Aliia, you have said that Dripa creates uncertainty in its alignment with BC laws. Do you think the courts are giving Dripa more legal weight than intended?
The way that it is being interpreted and taken by provincial courts is a complete conflation of the federal jurisdiction that exists within Indigenous nations, which are Indian Act bands under the Indian Act, and Section 35. So when you have these kinds of jurisdictional lines being crossed over, misunderstood, the public is now trying to get involved in the conversation. That's very complicated. I absolutely feel like we need to clarify. We need to move forward in frameworks that are fair and that offer certainty to the public and Indigenous nations alike. And governments are responsible for creating and aligning those frameworks. And right now we have duplicity between the provincial governments Dripa, which is a version of UNDRIP, and UNDRIP being used as the guiding principles. And so I think that there's a lot of work to be done to make sure that frameworks are going to serve the purpose that they're there to do.
And do you think then, Aliia, that there have been unintended consequences here?
I absolutely believe so. We're seeing that with the two court cases that have been talked about a lot lately in the news. And look, the issue with going to court is this. We have things that are tied up in litigation for years upon years upon years. Then we have an appeal. Then it gets elevated to the Supreme Court of Canada. So when we have projects or proponents or deals that even Indigenous nations themselves want to move forward, and it is trapped in litigation under a legal statute that is having to be interpreted by the courts, that conversation is no longer in the hands of governments. It's in the hands of judges and lawyers, and that's not where it belongs. And so we need to roll back and look at a framework and create that certainty and that clarity. The example that I give is we had 3 treaty nations come and talk about their treaties to give us an understanding of exactly how those agreements were made. And under those agreements, there's clear lines, decision makings, frameworks, allocations, but even those treaties have a clause where they can reopen them over time to take a look at things that were missed or different legislative operations that have changed that now affect the effectiveness of that treaty. So anything that we create in conversation, we need to have the ability to go back and take a look at and create clarity.
Robert Phillips, I imagine you would like to respond to that.
Yeah, Aboriginal rights and title, as well as treaty rights, are enshrined in the Canadian Constitution under Section 35. It can't be any more clearer than that. You can have, and that comes from the highest court in Canada, the Supreme Court of Canada. So you can have many court cases over and over and over and over, but there is still Aboriginal and treaty rights on the ground with Crown title. And so this is very important because what this framework of Dripa is doing is this framework is setting up a process where it will, amending it, abolishing it as especially would undermine economic, certainty. It would undermine reconciliation because we would have to take 2 steps back and then make 1 forward again. And I do believe it will interrupt shared prosperity because I think it would lead to even more court cases. Court case after court case, almost like decades ago, where there's uncertainty and this fear-based reaction that we've been getting from governments, officials, government politicians as well. It's almost like a racism, a prejudice, an act that people are fear that First Nations would have goodness gracious if they had decision making on their lands. It just doesn't make sense. And I believe this narrative does blame First Nations, in the whole scheme of things. And here we are in this blame, conflict, potentially even increased litigation. And this is what we're trying to avoid by, anytime when we hear that they want to appeal the court case, they want to amend the Declaration Act, we do believe right now it's part of that fear-based response.
Aliia?
Reconciliation isn't about a single statute. It is a long process that's rooted in constitutional law, court decisions, and relationships that took decades to build. I know some of the front runners and some of the activists and the chiefs that were on the front lines, making sure that Section 35, Constitution trained days, George Manual, that those rights were going to be enshrined and that they would stand forever in the test of time. What I don't understand is why we're conflating a BC legislative statute with those rights. Because in the beginning of Robert Phillips' response, that's exactly my point. Those rights are not going anywhere. They're there to stay. They're there in the Constitution. And for a long time, as I said in the beginning, Indian Act bands or First Nations have been the responsibility of the federal government. That jurisdictional line is very clear. So when we start to conflate provincial frameworks and agreements, and have that duplicity of Dripa and UNDRIP, of course there's going to be confusion. On the other side of the coin, it's exactly my point that he's proving right now, that if Dripa has become such a focal point, and now provincial courts are having to interpret through it, as we're seeing. I take offense to that. I would be racist or have racial undertones towards my community. Of course, I want these conversations and reconciliation to move forward. But we have to do so that we're in lockstep with communities, with the questions around economy, with the governments all being on side with Indigenous leaders. In reconciliation, it's a conversation that we have to have together, and we cannot get too far away from one another of where we're at in our perspectives, or I think reconciliation itself does suffer. But it's not because of one single statute. It is because we're now not seeing eye to eye on what the end goal is. It's clarity, it's certainty, it's investment, and it's, of course, retaining and maintaining the integrity of Indigenous leadership and all of the work they've done to get us here. But we need to be able to sit down, turn the page, and look at what the current issues are clearly.
I guess, Robert, if under Section 35 we have a guarantee of Indigenous rights and title from the highest court in the land, from the Supreme Court of Canada, what is the point of Dripa then exactly?
It's a framework. It's simply that. It's a toolbox. It's something that we can use to start implementing. We have tons of recognition. Everybody recognizes First Nations, but it is a implementation tool of our Aboriginal rights and title, our treaty rights. Ultimately, we want to see, as per Section 37 itself of the United Nations Declaration on the Rights of Indigenous Peoples, which is treaties, agreements, and other constructive arrangement. It's not only about Dripa, it's the United Nations Declaration of the Rights of Indigenous People, which is the basic human rights. And this is a framework where we can actually implement it throughout all of government, through the alignment of laws, through policy procedures, through monitoring enforcement of these major projects that are coming up, as well as what we heard on the news in regards to healthcare, education. It just goes on and on. What could be done in a positive moment in this time in history to take a step back will take us back decades, and it will lead to protests, direct action, court case, one thing after another. We haven't seen any alternative. This is the only game in town. This is what we have to do right here, right now, to make the next 150 years a positive next for our generations to come, for all of British Columbians.
Robert is not alone here. There's a letter signed by 100 First Nations. It says if Dripa is amended, it will undermine reconciliation. It will increase conflict and litigation. Do you see where those nations are coming from?
I do, and I understand why we have such a heated debate. And I talked about this early on in my comments. What we have is a conflation of understanding what a BC legislative statute can do and what it can achieve. And Robert Phillips also made that point for me. It's a framework. It's a tool. It is not the rights themselves. When we talk about UNDRIP, we're talking about what exists at the federal level. And that is actually what applies to these Indigenous nations, many of them, probably many of the 100 that you're talking about, because we don't have very many treaty nations in British Columbia. That has been ratified and passed by Canada. And the federal government is the jurisdictional body that has that direct responsibility and relationship with nations. And so we're actually, as I said before, duplicating. And when we have this duplicity, and again, we're forcing BC Supreme Court to interpret a decision between a nation and a proponent about early engagement, and we're using Dripa, the very words written on the page, to interpret that decision, then judges are tied into something that is now going to apply to all other nations as a precedent. And that precedent may not benefit other nations the same way it does the initial nation that made that court case. So when you talk about 100 nations coming on to sign, I'd like to know what the other 100 nations think about it.
Robert, the Cowichan ruling back in August affirmed Aboriginal title over a portion of Richmond, and the Angus Reid Institute subsequently conducted a poll to gauge public sentiment on that. They found that 3 in 5 British Columbians believe that decision to affirm Aboriginal title had the potential to somehow damage reconciliation because it threw fee simple lands into question. Does that concern you?
We need to let British Columbia, especially all Canadians, know that when it comes to Aboriginal rights and titles with Crown title on the ground, there is fee simple is just one of many, many claims, like in regards to on Aboriginal and Crown title lands. And that's what we're trying to figure out. That's what treaties, agreements, and other constructive arrangements are all about. But here we are in a situation where, again, fear mongering. Saying that people will lose their land, that they can't do business. Banks are saying, no, you can do mortgages. It's business as usual. We look at an example for, up in Haida Gwaii, you still have to stop at stop signs. You still have to pay your property taxes in the morning and every year. And so all of these things are, in place. But what this one really is about is minerals and tenures. And it's about, same thing. British Columbia was a proclamation in 1872 where it is now hereby British Columbia. And we still have to deal with Aboriginal title on the ground. So what this is, in regards to this work, is reforming all the laws in British Columbia to align with the United Nations Declaration on the Rights of Indigenous Peoples. We need to do that in order to expedite these processes that they're talking about in terms of minerals and critical minerals and all of those things in major projects. And so we want to do that by, making sure that the impact to the environment, our water, land, resources, it's not taken at all costs, that there's revenue sharing. And I do believe if there's revenue sharing across British Columbia, then that will prosper all of rural, northern, isolated, interior and coastal First Nations. And so I do believe that we have to get to a point where we co-develop those laws and legislations and jurisdiction, and we get the consent that's necessary from First Nations in order to do that work. And through this engagement and capacity, as well as environmental assessments and monitoring, and making sure the environmental standards are upheld. And I do believe if we do that, that this will create an economic certainty. It will build not only First Nations and all British Columbians, it will utilize our sovereign and traditional knowledge. It's all there in terms of the work and partnerships that we can do together. And that's what I'm saying. We have to do this, and we have to do it now, because if not, then the consequences could be dire.
Aliia, I guess, is the difficulty here that Indigenous rights, as we've heard, are enshrined already by the Supreme Court of Canada? This act is about the implementation on the ground of those rights. It requires action. And is that part of the difficulty or the reason, especially non-Indigenous people, are having trouble with this? Because this is going to result in real action versus it takes the Section 35 out of the books and puts it into practical form.
I don't think that the difficulty, again, I go back to public discourse and the understanding of this very complicated issue and topic and the layers of jurisdiction when an average person is going to come to the conversation and offer what they may think is a correct opinion on the history of all of this and how we've gotten to this point. I think it gets pretty messy. And that's okay. I mean, that's what happens. But as government, as I'm a sitting MLA representing 50,000 constituents, I need to make that sure that I'm representing my constituents, that I'm representing their voice and their concern, and that the communications are happening very clearly. And what we have here is we need to have a catch-up period where communications around this issue are going to create clarity, they're going to create certainty, and that as a province, we're going to make sure that we're offering that to the public in a very clear way.
We are going to have to leave it there this morning for time. It's so good to hear from both of you on this subject, and I hope we're helping people understand it a little bit better, but we'll continue talking. Thank you.
Coach Sam, thanks.
Thank you so much, Stephen.
Appreciate it. Conservative MLA for Chilliwack-Cultus Lake, Aliia Warbus. She's a member of the Stalo Nation First Nation Summit Political Executive. Robert Phillips, member of the Canim Lake Band.